So let's now hear from the chairs of our 4 committees who studied each and every one of these subjects over this 1-year period. And if they're going to be our so-called lighthouse in charting the course for us, let's hear a little bit about the rise of the machines with respect to technology, the law school crisis with respect to legal education, the do-it-yourself law or the denial of affordable legal services to the masses, and the entrance of the non-lawyer in the bar admissions.
The technology group has sort of broken our areas of study into 4 areas. Those areas are integration of technology into law offices, courtroom technology, technology that performs legal/lawyer work, and being optimistic that we are areas of work and employment opportunities created by technology. There's no question that technology is going to impact our practices. It's already impacted our practices. And I think the challenge for Vision 2016, for the Florida Bar, and for all of the subgroups, including mine, is how do we predict what's going to happen in the future. And our group has looked at this probably a little bit more simplistically, and that answer is the technologies that already exist are the ones that are going to be affecting us. There's technologies that we have seen evidenced by the presentation today. Obviously, those are technologies that already exist in the world. The question is, how much adaptation do those have to have in our law practices for us to be successful? And what level of technological competence does the future lawyer have to have in order to be successful? And the way that our committee is looking at this right now is to say which technologies are going to be the most prevalent. And in that way, we're not identifying specific products. We're just identifying specific processes and technological advancements that we expect to be incorporated into what we now consider to be the traditional law practice. And if you haven't already started to incorporate those, we envision recommending that you do start incorporating those. And we're going to go beyond that. We're going to recommend some I expect, we still have 2 years to go, some institutional change, both within the Florida Bar and within the court system, to the extent that we can affect that change within the court system, so that these processes, as they're ever changing, will be known to the bar as early as possible and will be advanced to the lawyers as early as possible. And it will be, I expect, the bar's responsibility, because if the bar doesn't take it on, it will be outside vendors. The bar's responsibility to educate the lawyers on the minimum standards of technological competence so that they can advance their practices. And Jordan has made the point at several presentations that we've watched, and I have slowly, begrudgingly become a believer that the efficiency that technology will allow for our practice will allow us to serve clients that we haven't traditionally served, and in that way, being the optimist that our committee insists on being, will broaden the marketplace. We have a firm belief that is going to occur and be beneficial for us, even if that means that certain practices that we're traditionally used to exercising aren't the same types of practices that we consider doing. So I know that's very generalistic, but I believe that when our report comes out in whatever form and function that finds, the end goal will be a practical application of technologies into your law practices and into the court systems so that we're ready for the next phase. I'll mention something that a lot of you may already know this. When I first found this out, I was shocked to learn it, as were many people. The Florida court system has its own technology group, and they advance the technological ball as they see fit, independently. They have already approved and will happen when they can make it technologically available, a TurboTax type system that will be installed in every circuit courthouse in the state to resolve the overload that pro se family law matters have on the court system. And so you will be able, the pro se individual, will be able to go into the clerk of court's office in the courthouse, and there'll be a computer there, and they will be able to, just like a TurboTax type system, check the box, fill in your name. Are you the petitioner? Are you the respondent? Do you have any children? How much money do you have? Check, check, check. Follow it on down till the end. Boom. It's electronically filed. You have now started the process of getting divorced. Obviously, this is intended for people that have the lowest level, true indigent status, but it's an example of how the court is already taking action, and how it will have some impact on certain lawyers. It will have some impact on maybe more on younger lawyers who otherwise would have learned their trade that way. But this is something that I would bet many Florida lawyers, this is the 1% in this room who probably is the most knowledgeable on these subject matters, have no clue is coming. And it's already a foregone conclusion. It's just a matter of when. And if that's happening already within our own state, within our own courtrooms, it's just evidence that we need to connect the dots. I've had a lot of talk with bar leadership to assure that the interplay between the bar and the court system and the attorneys and, as Jordan mentioned, some of the other groups that are working on this happens, because otherwise we may come up with inconsistent results. So I've already spoken way more than I intended to. It's an absolutely daunting task. I have no idea. I appreciate Jerry Riskin's comments. The only way that you can ever accomplish this task is if you really refuse to act like a lawyer, because every single time that we try and decide what our product is going to look like, we get paralyzed because the future of this seems absolutely daunting and overwhelming. But the process has been enlightening, and I think that we will come up with a very practical and useful product for Florida lawyers to adopt. So with that, I will do it. Who would I hand it over to? You, Jay?
Yeah, if you would. I just have one last question for you, name and product.
Well, hopefully that will happen before we're done. We are at the direction of President Coleman. We're retooling LOMAS. I think, we recognize that there's an immediate need for lawyers to be aware of technologies, products, tools, and solutions that are already available that they should be using. I think we will probably stay away from identifying specific products, but it will be our intention to ask the bar, and to the extent we can, to ask the Board of Governors to direct the bar to come up with exactly that. If LOMAS is not, or the retooled LOMAS is not already doing that, then that's going to need to be made available to the Florida lawyers, and I don't think there's going to be a better entity that can do that than the Florida Bar.
The general approach of our subgroup has been, dear friend of mine, Tony Boggs, worked for us a long time. He used to use a statement, we've redoubled our efforts but lost sight of our goals. So the first year we spent researching and looking at everything we could, much of what you've already seen here about what needs to be changed, what needs to be the goals of legal education. Where we're at now, however, is we've discovered probably what, if we did a survey of everyone around this table, would recognize. In the 1870s, C.C. Langdell started a revolution in legal education at Harvard. And very simply, he said, it's all about the mind. And as long as we get straight A's in law schools, learn the IRAC method and the Socratic method, we're fine. The Carnegie Institute recently found that we do a great job of educating lawyers about the law and knowledge. not so good a job at skills, but better, and a horrific job of practical skills and a horrific job of formation of a professional identity, the culture of what's going on. And every school is pretty much the same way. Now, what our group has found is, and in its list of competencies, it's pretty well agreed with what much of Carnegie found, is that to be a great lawyer, you have to have more than just the knowledge and even just the skill sets, but you have to have all of the skills of being able to, as a human being, to be able to represent other people. One of the things you did not see up there is that the depression rate of lawyers and the depression rate and suicide rates of law students is by far the greatest of any profession. The stresses on us, the type of work we have is extreme. And so, Jay, to answer your question, I think what we found out is that we have to work a lot harder in a lot of areas that law schools have not been working on in the past. What we've also found out is that in the upcoming ABA meeting coming up, there's a big packet of accreditation changes. And as said earlier, those changes are more incremental. Medical doctors get 2 years of clinical study and then an internship. We've moved to require in law schools to require 6 hours and 3 years, 6 hours of experiential or practical learning. And so I think what this group is going to focus on is not only tinkering with the system. I think you're going to see, and they've already said, we're going to look at the bold possibilities first. We're going to look at the kinds of changes that would be able to say, we're going to look at a medical model. Is that out of the realm of possibility? We're going to look at the Washington and Lee model of the whole third year being experiential. Is that doable, and if so, how? And very quickly, so you can move on to the others. What we know from this subgroup is maybe our group, more than any other group, really has a tough time for change because there's so many political powers and people involved. You have to get accreditation change. We can't do it all ourselves. And so we have to do changes both incrementally within our state and then try for the bigger changes farther out and see where we go with it. So the group is excited about the future, but it's got a big challenge ahead of it.
Hold that for one more second, and that is, in your group's discussions, do you expect and anticipate that there's going to be a move afoot coming out from your committee that is geared towards a change in curriculum as a recommendation geared more towards the skill set of lawyers coming out of law school as opposed to what they I think termed at one point the head of the lawyer?
Jay, I think the very use of the term curriculum is in a way a little misleading. I think it's more than just curriculum. It's the culture of the school and how you go about inculcating the skills and the values. So it's more than just we're going to change this course, and this course. The committee has already said that as we go into this next stage, we are going to look, that group is going to look as much as possible as to what ways you're going to get at the competencies they've already said. And that's going to be clinics, that's going to be simulations, that'll be new courses. It'll be it may be a medical type model that will be devised, but it's going to be something a lot bolder than where we're at. But at the same time, being realistic that you've got to get constructive change somehow, some way.
Imagine being given a committee name, and that's all you were really given. Delivery of legal services / pro bono. I mean, I consider myself a fairly sharp person, but I have to tell you, I had days and days, ask Jesse, of angst. What am I supposed to do with this committee? I'm serious. What am I supposed to do? What does this mean? It doesn't mean that I'm going to tell you, Heiger, how to deliver your legal services. It's not going to tell you that you ought to have a different model and you're going to only charge so much. The word pro bono was a clue. I guess what we're talking about is getting more people access to lawyers. I don't know. Is that what it is? So let me tell you how it evolved. First of all, at the same time that I was appointed and our chair and our committee was formed, I found out the foundation had hired a consultant to do almost this very thing, to really look at the delivery of legal services to the poor, to the indigent. And they were doing it through their existing system, which is legal aid. So they kind of had that covered. And I have to tell you that I was happy about that because I thought that was a piece that we didn't have to deal with, because I have a particular bias, and that bias is that 85%, which of course includes the indigent, but so many more people that cannot afford legal services. What does that mean to you when I say legal services? One of the things I learned, and that my committee has embraced, is legal services does not mean access to a lawyer. We are not trying to find out how everybody can afford a lawyer. So what we did was, and I made this recommendation because I wanted the perspective to change. So we call it now, instead of delivery of legal services / pro bono, it is now called access to legal services. And the bar was kind enough to hire a consultant for us, a national expert, because I have to tell you that without that national expert, I wouldn't be sitting here today with an action plan that we had in 2014 of April of 2014, or one that we are currently working on, a piece of it, which is called the short-term action plan. There is no way. I'd still be studying all of the treatises and the articles and the forums and everything that I have been getting almost daily from all angles, the blogs and all of that. So I forgot your question, Jay, but
No, but it's good that you're venting.
Yes, it's very cathartic for me. So, but I just have to tell you that how it is so difficult to figure out what our committee was originally going to do, and there were so many different perceptions of what we should be that I've already had 2 people resign in the last 2 days. 2 very prominent people have resigned because they informed me that they don't think that this committee is going in the direction they originally envisioned. Now, there are about 15 people on the committee who are still hanging in there. I don't know yet, but I will tell you that as I sit here today, we have the action plan. It's a 6-page action plan. I don't know who's reviewed it, but what we did was we took every possible angle of any state that's done anything of any prominence, Illinois, California, Washington. We took concepts, I don't even know what they meant, stratification, triage portal, navigators, things that you wouldn't even think about. We're not just talking about somebody coming in and talking to you. We're talking about the ability of someone to go into court and get some kind of legal service. Well, in the meantime, now we're going to have, which I think is a great idea, we're going to have a summit. We're going to have more access to Justice Commission, which is really where everything gets kicked off in these other states. So my committee and several members said, what does that mean for us? Where do we go with this? Are we going to be subsumed into a larger movement? But there was one piece of it that we felt like we could do and that most other states have done, and we haven't quite done it yet. So this June 5th action plan is for a limited scope representation rule amendment. And that's what we're engaged in now. I have a subcommittee that's actually engaged in looking at all the angles, looking at what we already have, looking at what all the states already have, working with other committees that are working on the rules. And that piece of it, we're going to absolutely come out, hopefully in September, October, we're going to come out, we're going to present it to you. That piece of it we're doing, but I feel we're a little on hold until we figure out what we want to do on an access to justice model.
Bar admissions, we are looking at really 5 areas. The first is multi-jurisdictional practice on the domestic side, MJP on the international side, alternative business structures or forms of ownership of law firms by non-lawyers, alternative service providers, which you heard Jerry make mention of, and the uniform bar examination. So let me take those in reverse order. The Uniform Bar Examination, which is known as the UBE, was first administered in 2011. There are now 14 states that administer the UBE, mainly concentrated in the west and Midwest part of the country. Washington State, Idaho, Utah, Arizona, Alaska, Montana, Wyoming, Colorado, North Dakota, Nebraska, Minnesota, Missouri, Alabama, and New Hampshire. And what the Uniform Bar Examination is what its name implies. It is a uniform bar examination that gives you a portable score. It has nothing to do with your status as a lawyer, but if you take the examination and pass it, you do have a score that you can move from jurisdiction to jurisdiction without having to retake the bar examination. States that administer the uniform bar examination still are in control of character and fitness for their particular state. They also determine the passing score for their particular state. And I'll tell you that in 2010, the Uniform Conference of State Chief Justices did pass a resolution endorsing the concept of the uniform bar examination. Also, the American Bar Association section of legal education and admissions to the bar also passed a resolution in 2010 endorsing the uniform bar examination. So where does Florida stand? And by the way, I should say that all our committee or all our board can do is study these issues and make recommendations to the Supreme Court. We don't have the ability, obviously, to change the rules of admission for the Florida bar. So I want to make sure that's very clear. Florida Board of Bar Examiners has been involved in our discussions and will continue to be. As you all know, the main thing that is driving all these issues of reciprocity, admission on motion, uniform bar examination is the increase in mobility of lawyers. It's an issue that is not going to turn itself around. You know, we are now in a new paradigm, and our profession has become more mobile. I, for one, have worked in a law firm, a national law firm that had multi-city locations, and in the short time, well, I should say short, it's not short anymore, 25 years I've been in Tampa. I recall moving to Tampa in '88, and it was a very large deal when a Detroit law firm named Dykeman Gossett moved to our city. Because I recall it was probably one of the first firms to have a presence in Tampa. In today's market in Tampa, there are now only 3 law firms of 50 more lawyers that are based in Tampa. It's pretty remarkable. And those firms are my firm, Trent McKemker, Hill, Ward, Henderson, and Gray Robinson, are the only firms that are based in Florida. Every other firm in our city that is 50 more lawyers is actually a regional or national law firm. So we're in an age now of mobility and multi-jurisdictional practice. The second issue I want to just make a brief mention of is this whole issue of reciprocity. Reciprocity is really twofold. The first issue is what is called admission on motion. States that recognize admission on motion allow lawyers to become members of that state's bar without taking the bar examination. There are now 38 states that recognize admission on motion. And of the 38 states that recognize admission on motion, 24 of them require or only recognize admission on motion based on reciprocity, which means that you cannot waive into those states unless your state also permits admission on motion. And so Florida clearly is in its own ecosystem, but I don't know where this is headed for a fact, but my suspicion is that the days that we will not be a state that recognizes admission on motion are probably fewer than the ones that are behind us, again, just because we're in a mobile age now. Something we're studying, one of the big issues in this area has been if we adopt a uniform bar examination and we have admission on motion, will it somehow denigrate the quality of Florida lawyers and their knowledge of Florida law? I attended a conference put on by the National Conference of Bar Examiners a few months ago, and one of the issues that states that have been administering the UBE were discussing was how lawyers have been integrated into their states, and remarkably, or perhaps not, none of those states said that administering the UBE has been an issue in terms of lawyers' knowledge of their own jurisdiction's laws. Some states have an online requirement that you take a course if you are coming in under the UBE, and some states don't worry about that and just administer UBE. And keep in mind the UBE is composed of 3 components. one of which is the MBE, which Florida already recognizes. Next issue we're looking at is this issue of alternative service providers. And again, this is something that has already been made reference to. I believe it was Jordan that made mention of this 85% below the waterline, and states looking for a way to bridge that gap and to provide services or to make legal services more accessible to non-lawyers or to clients. And one state, the state of Washington, in 2012, passed a new admission rule under which they license a new category of, I call it paralegal. The technical term is limited license legal technicians. These are essentially paralegals that are allowed to provide services directly to the public without the supervision of a lawyer. The first area approved for that new practice area or designation is family law. California, and I believe New York are also looking at some form of alternative service providers. And again, this fits into the new paradigm where I believe there are going to be a lot of, I'm not sure I call it breaches anymore because it's just what we are now, but other forms of services, other ways that consumers have access to the legal market. I just read an article that in May of this year, Walmart stores in Toronto are now offering legal services. And so we thought about, many years ago when you go to, a drugstore and maybe get a physical, and that's now routine. And, you think about the medical profession, and those of you that maybe have needed a prescription last minute, you know how difficult it is to see a physician. You can sometimes have to wait months. But physicians' assistants and the medical field have greatly, I think, increased access to medical services. So, again, these are all things we're looking at for the Florida Bar. And the last thing I've mentioned, and I would say from our committee standpoint, has gotten the least traction, is this concept of alternative business ownership. Firms in Australia, some law firms in Australia and Europe do provide for ownership of law firms by non-lawyers. I would not say that is a non-starter in the U.S., but in terms of the immediate changes, I would say that's one that our group just has not been enough study out there on that issue for us to feel at this point we're going to make any probably immediate recommendations on. But again, that's something out there, and as we move toward more global economy, that could eventually work its way to the U.S. Only one territory so far permits that, and that is the District of Columbia.
Thank you, Lance.